Excellent. Most of you have done so. So let me make a start. Good morning, ladies and gentlemen. Welcome to this Freedom of Information, Rights and Responsibilities webinar. My name is Ibrahim Hassan. I'm a solicitor and director of Right Now Training. And for the next hour or so, I will be explaining to you the basics of the Freedom of Information Act and also answering some of your questions as we go along. So feel free to type your questions into the chat function as we go along. The Freedom of Information Act then. The whole idea with the Freedom of Information Act is that any recorded information held by approximately 130,000 different, mainly public sector organizations, is potentially accessible by anyone, anywhere. Anybody who wants to see any information held by any of those public authorities, they just have to make a request, as we'll see later on in writing, and they should get that information, unless, of course, an exemption applies. Does anybody know when the Freedom of Information Act came fully into force? Type your answer into the chat function. I should warn you, if you don't ask me questions, then I will ask you questions. So does anybody know when did the Freedom of Information Act come fully into force? If you think you do, or take a guess, type it into the chat function. Lindsay says 2001-ish. 2000. Says Belinda. Anita thinks 1995. Maria says 1996. The Freedom of Information Act 2000 actually came into force on the 1st of January 2005. So if you didn't know that, you might want to write it down just in case you attend a pub quiz tonight. Anybody attending a sad pub this evening? All recorded information held by 130,000, mainly public sector organizations. Who are the biggest users of the Freedom of Information Act? Well, journalists, probably, but members of the public are not that far behind. Every week we read stories in the papers, on the internet, where the information has been accessed through the Freedom of Information Act. Journalists, it's fair to say, are the biggest users of FOI. As I say, members of the public also use FOI. Even companies, unions also make lots of requests as well. So all these stories have come about as a result of FOI requests. Everything from spending to expenses, etc. Does anybody watch Have I Got News for You? Raise your hand if you do. A few of you. 5 out of 10. Okay. Well, you'll know this, and the rest, well, this is about who is the odd one out, but from a freedom of information perspective. So it's not as funny as the real thing, but take a guess anyway. Who do you think is the odd one out from a freedom of information perspective? Any thoughts, anyone? Spider-Man, says Anita. Anybody else? Oh, says Maria as well. Any other thoughts? Trump, says Sarah. Anyone else? Or Sarana, sorry. Okay, I'm going to keep you guessing. I'm going to leave you in suspense until the end, of course. Just remind me. I'll go through that. Okay, when does the Freedom of Information Act apply? Well, it applies to all of you because you're public authorities. We've got people attending from local authorities, from the Foreign and Commonwealth Office, from a university, from the NHS and various other bodies. If you're in any doubt, you would look at Schedule 1 of the Act. Primarily, the Freedom of Information Act applies to public authorities as set out within Schedule 1 of the Act. But that's not the only type of organization that is that freedom of information applies to, it also applies to publicly owned companies. Publicly owned companies. So, contrary to popular belief, freedom of information does apply to companies, but they've got to be publicly owned. And I'll go through the definition. Everything I say will be based on the codes of practice. Now, previously, there were 3 codes of practice under FOI. There were 2 under Section 45, one on how to deal with requests, and the other one to do with data sets. If you get a request for raw data, then that would come under data sets. And then the third one was related to records management. Now, since July of this year, there are now only 2 codes of practice. The Section 45 code amalgamates the 2 previous codes. So it includes provisions relating to data sets. So there is a new code of practice which came into force in July this year under Section 45, replacing the previous one and also amalgamating the Section 45 code on data sets as well. And then the records management code remains the same. So now 2 codes of practice instead of previously 3. So back to when freedom of information applies. We know it applies to a public authority or a publicly owned company. What's a publicly owned company? Well, any company which is wholly owned by the Crown. So we have colleagues here from the Foreign and Commonwealth Office. If the FCO sets up a company, I don't know, to promote trade in a particular area of the world, etc., and the FCO owns all the shares in the company, that is a company wholly owned by the Crown, it is subject to freedom of information. As far as the rest of you go, wholly owned by any public authority listed within Schedule 1. So if as a local authority, you've set up a company to regenerate a particular part of the district, you own all the shares, and that company is subject to freedom of information. You may have outsourced your leisure services. An arm's length company is managing your parks and open spaces, or crematoria. In some areas, the local airport is owned by the local authority or a number of local authorities together. Where I live, we have the Yorkshire Purchasing Organisation, a company set up by a number of West Yorkshire authorities to buy and sell services and goods as well. So any company which is wholly owned by the Crown, government department, or wholly owned by you alone or jointly with others. So another example is, we have colleagues here from a university. Universities often set up companies to deliver training or to exploit copyright and other research. That company, if all the shares are owned by the university, that company is subject to freedom of information. Anybody have any other examples of companies that they work with that would come under wholly owned and therefore publicly owned under FOI? Any other thoughts, anyone, of examples of companies that you advise or that you are part of that would be subject to freedom of information? Type your answer in the chat function. NHS CCGs, Maria. CCGs are actually separate public authorities for FOI purposes. They are they have been added to the list under Schedule 1. So they are a public authority in their own right, as opposed to publicly owned companies. Any other thoughts? Okay, let's move on. Does anybody know who that person is? Any thoughts, anyone? ICO, says Lindsay. Yes, it's the Information Commissioner, Elizabeth Denham. That's right. She is in charge of enforcing the Freedom of Information Act, as well as the new data protection legislation, GDPR as it's known, and other legislation in the area of information governance. She has a number of sanctions at her disposal. If you don't comply with freedom of information, she can investigate, she can issue notices on your organization, like decision notices as well as enforcement notices. If you don't comply with any notices, it's punishable as though it was a contempt of court. But what she can't do under freedom of information, which she can, of course, under GDPR, is fine organizations. The commissioner under FOI does not have a power to fine organizations, but usually when she investigates and she decides that she wants to make you disclose information, for example, or perhaps you've taken too long to deal with a request, then obviously that will be publicized in the form of a notice, and that will lead to obviously adverse publicity as well. So she doesn't really need to fine organizations, nor can she under FOI. Once we know that the Freedom of Information Act applies, we've got to ask ourselves, well, what do we have to do? First of all, every organization has got to produce and then comply with a publication scheme. Raise your hand if you've read your organization's publication scheme. 2 out of 10 of you have read the organization's publication scheme. Well, this is very important. Every organization, every public authority or publicly owned company has to have a publication scheme. And basically, that's just a document which sets out what information you make available to the public, where it is, and whether or not you charge for accessing that information. So that will be a document which is probably on your website. And the idea is that anybody who wants information, first of all, they should look at the scheme, because you may already publish it. It may be in the on your website, it may be in the library. The publication scheme should tell you where it is. Section 45, the new code of practice, also says that you should produce a guide to your publication scheme, and you should set out a schedule of fees to go with the information, so people know exactly if they are to be charged for any information which is in your scheme, they should know how much they would have to pay. So that's a publication scheme. It is important that you read it, because information that you routinely make available, if somebody makes a request for that information, then all you have to do is point them in the right direction. You don't have to actually give them the information again. Section 21 would apply. Information is reasonably accessible. Therefore, it's exempt from having to comply with that request. So put it down on your action plan. You must read your publication scheme. You must update it from time to time, review it. The more that's in the scheme, hopefully, the fewer requests you will receive. But applicants are not just restricted to what's in your scheme. They can ask for any information under Section 1. Section 1 is the right of access. I'll let you read Section 1 for a moment. Maybe even tell me what you think. What's Section 1 saying to you? Because this is really what it's all about. Section 1, the right of access. Have a read and tell me what you think. What's it saying to you? Any thoughts, anyone? Section 1. Yeah, if we hold it, you can have it, says Anita. Maria says we need to be open and transparent. Absolutely. Yes. Yes, you're along the right lines. Let's start from the beginning. Section 1. Any person can make a request. So you don't have to be an individual to make an FOI request. Companies, organizations, community groups can make freedom of information requests. Anyone, anywhere can make an FOI request. Do you have to be a British citizen to make an FOI request? Raise your hand if you think yes, you have to be a British citizen to make a freedom of information request. Anita says no. Absolutely right. Yes, anyone, anywhere can make a freedom of information request. It talks about request for information. Do they have to mention the Freedom of Information Act for it to be a valid request? What do we think? Yes or no? No, they don't have to mention freedom of information. A request for information, well, has to comply with 5 conditions. And this is important for you to understand and learn, so that if you do get a request, then you don't reject it or ignore it, or your colleagues don't reject or ignore it on the basis that, well, it doesn't mention freedom of information, therefore we don't have to do anything. A request for information, according to Section 8 of the Act, has to satisfy 5 conditions. First of all, it has to be in writing. In writing. So email is okay, a request by Twitter is fine, Facebook is okay as well, or somebody could just write you a letter if that skill is still prevalent amongst the community of writing these days. We're all on our electronic machines, but if somebody writes or sends a fax, that would be okay as well. A purely verbal request is not technically an FOI request. So in writing, it's got to be legible. You've got to be able to read it. Thirdly, incidentally, the Section 45 Code of Practice says that a request has to be in English as well, or English or Welsh. No need to deal with a request which is in a foreign language. Thirdly, you have to have a name. The requester has got to supply their name. What if you get a request from a superhero? Would that be a valid request? Raise your hand if you think yes, Spider-Man can make a request. Raise your hand if you think no. The noes have it. Technically, Spider-Man is a pseudonym according to the Information Commissioner, therefore you are not required to deal with that request, only if he is real. Of course he's real, Lindsay. Spider-Man is real out there fighting crime. Just can't see him. So obvious pseudonym, Mickey Mouse, Spider-Man, Batman, Green Goblin, it is not a valid request according to the Commissioner's guidance. Of course, when you're dealing with superheroes, well, you want to be helpful, don't you? I'm not sure about that case, Anita. Certainly, if you read the Commissioner's guidance about valid requests, it does mention Mickey Mouse and says that it's an obvious pseudonym and therefore not a valid request unless the individual can send you a deed poll or something to suggest that they have changed their name. There's legal issues with regards to that guidance because technically anyone can call themselves anything in this country. So I'm not sure whether that guidance is correct, but that's what the Commissioner says and that's what we'll go with. Address. You have to have an address. It doesn't have to be a land address, it's an address for correspondence. So it can be an email address. They've got to supply enough information so that you know what they want. If you have to go back to them because they are not clear, then you can, that your time doesn't start. That's the first thing. And you can go back to them. In fact, it's part of your duty of advice and assistance. So Section 1.3, where you reasonably require further information to identify and locate the information, and you've told them, then you're not obliged to comply with that request until they've supplied you with further information so that you can identify and locate the information. They can't just ask a general question like, why did you build the roundabout there? Or why are you wasting public money? And of course, though, do bear in mind that Section 16, advice and assistance, you've got to be helpful. So you cannot refuse on technicalities. You don't have a name, you don't have an address for correspondence, etc. You've got to be helpful. You've got to try and help the applicant to bring their request within FOI. That includes keeping them informed of their request. That includes acknowledging their request. That includes allowing them to reduce the burden in terms of fees. All part of advice and assistance, being helpful. But then you're all public sector servants. I'm sure you're helpful anyway. The Act talks about information. What is information? Information is information if it's recorded in some form. So it's got to be recorded in some form. Whether it's on paper, on computer, video, audio, CCTV, images, even manuscript notes. Anybody taking notes at the moment? Raise your hand if you are. Very good. You're paying attention clearly. Well, remember, your notes are also subject to freedom of information because it is recorded information held at the time the request was received. It's got to be held, i.e., if you previously deleted the information before you received the request, that's fine. It cannot be a valid request. You can say, no, we don't have the information. You don't have to own the information. So, for example, an NHS trust may receive a consultation document from a CCG, or may receive a tender from a company to build a new hospital. The fact that you do not own the information doesn't mean that it's not information subject to FOI. The fact that you hold it at the time the request was received means that it is potentially accessible. So any information, it's got to be recorded in some form and held. Information which is in your senior manager's head, because obviously there's a lot there, that's why they're managers, aren't they? If they haven't written it down anywhere, then it is not subject to the Freedom of Information Act. Information which is just purely gossip, rumor, never written down, never recorded anywhere, it is not subject to freedom of information. Now, some people say freedom of information only gives access to facts and not opinions and not judgment calls. That is incorrect. Freedom of information gives access to anything which is recorded, subject, of course, to the exemptions that we're going to have a look at. So that is the right of access. Any questions so far? Feel free to type your question into the chat function. Alternatively, you can ask me to unmute your line, and then we can have a discussion. Remember, there are two duties under Section 1. There is the duty to confirm or deny the existence of the information. And you will note that that says it has to be done in writing. So even where somebody asks for a information from a local authority, and say they ask for information about trading standards, but you don't have trading standards. It's not a department. You're a district council. In that situation, you do not hold the information. However, you've got to go back to the applicant and say, we do not hold the information. You've got to do that in writing. If you hold the information, then you've got to communicate the information to the applicant. Communicate the information to the applicant. Now, it doesn't say there it has to be done in writing, because here we have to look at Section 11 of the Act. Section 11 tells us about format of our response. Okay, so we'll come back to that. So two duties under FOI: confirm or deny in writing whether or not the information is held, and if the information is held, communicate the information to the applicant. How long have you got to do that? Any thoughts, anyone? 20 working days, says Belinda and Maria and Anita, as well as Sarana. Okay, 20 working days. Absolutely right. 20 working days, Monday to Friday, excluding bank holidays and other public holidays. So you haven't got a lot of time. That means that you must make your colleagues aware that a request can come in at any stage, and any request for information in writing, giving you a name and address of correspondence, is technically an FOI request. Of course, there are some requests which are business as usual. You know, somebody sends an email to a local authority, what time does the swimming pool close today? Technically it's FOI, but you're not going to treat it as FOI, you're just going to deal with the request. So 20 working days. When do the 20 working days start from? From receipt, says Anita. So does Maria. So does Sarana. Anyone else? because you're all wrong. Yes, Jonathan, it's the day following the date of receipt. So if the request is received on the Friday, it's technically the next working day. So that would be Monday, unless, of course, Monday is a bank holiday. So it's not the date of receipt, it's the day after, the next working day. Okay, that's important. That means that perhaps some of you have gained a day by attending this course, which is all good, isn't it? 20 working days from the day after the date of receipt. 20 working days to confirm or deny the existence of the information, 20 working days to communicate the information to the applicant. When we talk about communicating, I mentioned section 11 of the Act. The applicant can express a preference as to how they want the information. But in the end, it's your decision. You've got to consider what's reasonably practicable and the costs involved. So somebody wants a copy of all the tender documents that you received when your university built the new faculty. That may contain 20 boxes full of information. You're not expected to copy everything. You can say, why don't you come in and inspect the information, and we'll give you copies of the relevant documents. They can ask to inspect a record. They can ask for a summary of the information. They can also ask for the information in electronic form, as long as it is reasonably practicable, and in doing so, you consider the costs involved. If they're asking for a data set, i.e. raw data, facts, figures, and statistics, perhaps details of university students, number of students on each faculty, the footfall at a shopping centre, perhaps, that you've measured as a local authority, NHS trusts, details about patients, anonymised information such as inpatients in A&E who are smokers or who came in with domestic violence related injuries. Those are data sets, facts, figures, and statistics. If somebody makes a request for that information, as long as it's not exempt, then Section 11 requires you to disclose that information in electronic form, which is capable of reuse. So it's got to be in an open, machine-readable format. But that provision only relates to data sets. Two duties. The good news is you can charge. The bad news is you can't charge that much. Let's look at the fees provisions then. Section 12, as well as the regulations related to fees. In deciding whether or not you have to disclose the information and how much you can charge, first of all, you've got to work out the time it takes to locate, retrieve, and extract the information. So somebody wants to know how many individuals did you discipline last year for being rude to service users? So you may have to read through lots of personnel files, disciplinary files. First of all, you have to locate those files. Then you have to retrieve them. Then you have to read through them and extract the information. You take the time it takes you to do that based on the hourly rate of £25 an hour. But that's not what you can charge. £25 an hour, hourly rate based on the time it takes you to locate, retrieve, and extract the information. If the cost of doing so, if the total amount is below £450, if you're anyone other than a local authority like university, NHS trust, council, £450, if it's below that limit, then you have to supply the information, and the only thing you can charge for is photocopying and postage disbursements. If you're a government department, colleagues from the FCO, then your limit is £600. So below £600, you cannot charge anything other than photocopying and postage. So government departments, it's £600. Others, it's £450. Remember, that's not what you can charge. That's the limit below which you have to supply the information, and you can only charge photocopying and postage. If it's over the limit of 450 or 600 pounds, then there's no need to supply the information. If you choose to supply, you can then charge £25 an hour. So over the 450 or 600 pound limit, you do not have to supply the information. Where you are charging for disbursements or where it is over the limit, you have to issue a fees notice. You have to tell the applicant in writing how much you're going to charge, and you do not have to supply the information until they pay the fee. They have 3 months in which to pay the fee before the request lapses. But don't forget your duty of advice and assistance. You've got to be helpful to applicants and potential applicants. If a cost is over the limit, you've got to give them opportunities to refine or rephrase their request. That is a sort of brief summary of the provisions relating to fees, what you can charge for a freedom of information request. Any questions on fees or anything else before we move on? Who has a policy of never charging for a freedom of information request? Raise your hand. If you never charge, that's your policy, you never charge for a freedom of information request, raise your hand. Raise your hand if you always charge for a freedom of information request. Okay, nobody raising their hand. Raise your hand if you don't know whether or not you charge for an FOI request. Okay, let us move on then. Any questions before we do? Feel free to type your question into the chat function. Okay, Maria says, occasionally you issue a fees notice. Okay, and do they pay when you do issue the notice, or do they just forget the request, Maria? They disappear, yes, and hence that's why a lot of organizations still charge, even though it costs probably £20 to issue an invoice and to process the fee. But there you are. Okay, the good news is that occasionally you will find people, well, it's not good news that you find people who are vexatious or repeated. They keep asking for the same information over and over again, or their purpose in making the request is not to seek the information, it's to make your life difficult. They may be a disgruntled former employee, a student who's failed their exams, a difficult patient in the NHS. There are two provisions you can use to deal with nuisance requests. Repeated requests, straightforward, they keep asking for the same information. Vexatious request, the purpose is not really to seek information. The purpose is to use FOI as a stick with which to beat you. If you feel that's the case, then you can take account of the volume, the frequency of the requests, the language that they're using, the burden on the organization. And you can refuse on the grounds that they are being vexatious. Okay, let us move on to look at the reasons for refusal. Well, mainly look at the exemptions, because we've already looked at the 4 other reasons for refusal. There are 5 reasons for refusal, or, as some would say, anybody know, reasons to be Susan, yes, thank you. Reasons to be cheerful. 5 reasons to be cheerful. Information is not held. You can only disclose information that you hold at the time the request was received. The request is vexatious or repeated. The costs are over the 450 or 600 pound limit, and a Part 2 exemption applies. In each case, you've got to issue a refusal notice under Section 17 of the Freedom of Information Act. You've got to explain which exemption or reason you are relying on, and what can they do after you issue a refusal notice? What's the next stage? Does anybody know? Once a refusal notice is issued, what can they do? They can appeal. Yes, who do they appeal to? If they don't, yes, before they appeal to the ICO, Maria, they've got to go through your internal appeals process. So you've got to give them a chance and give them details how they can ask you to internally review their decision. Only then can they go to the Information Commissioner's office. Okay, let us move on then to look at the exemptions. There are two types of exemptions under the Freedom of Information Act: absolute and qualified exemptions. If it's a qualified exemption that you're relying on, then it's not enough to say that the exemption applies. You've got to apply what is known as the public interest test. You've got to ask yourself, does the public interest in withholding this information outweigh the public interest in disclosure? So, for example, a qualified exemption is commercial interests. You may not want to disclose information about the price you paid for goods or the tenders that you received because you feel that to disclose that information would harm your or your supplier's commercial interests. But because that's a qualified exemption, in your refusal notice, you've got to explain why you believe secrecy is better than openness. So you've got to consider factors such as disclosing may help openness and transparency and accountability, allowing the public to see how you spent their money. Any dangers to their health and safety may be disclosed as a result of disclosing the information. It may contribute to a debate of importance if you disclose the information. So those factors have got to be considered against the harm of disclosing the information. And that's got to be explained within your refusal notice when you're relying on a qualified exemption. If you're relying on an absolute exemption to withhold information, then there's no need to apply the public interest test. These are the absolute exemptions. Section 21, information accessible by other means. Information accessible by other means. Section 21, information, if it's available through your publication scheme, information about land ownership from the land registry, companies, company's house, then you do not have to disclose that information because they can get it elsewhere. Section 21. Information supplied by directly or indirectly by the security services, MI5, MI6, GCHQ, etc., etc. It may be information about security which has come from the police. Section 23. Court records, information which forms part of a record which has been submitted to court, a document submitted to court, something that's come from the court, letters, court orders, statements of case, defense, pleadings, etc. Section 32 applies. Section 34, parliamentary privilege. This can only be applied by the House of Commons and the House of Lords. Parliamentary privilege recently was debated when Peter Hain decided to disclose the name of the businessman who was the subject of sexual harassment allegations. Section 34, public affairs, the House of Commons and House of Lords, if they're relying on Section 36, it's an absolute exemption. Communications with Her Majesty plus the next two in line to the throne. If Prince Charles visits your council offices and then emails you, texts you, commending you on the architectural appeal of your building, that's an absolute exemption. You don't have to tell anyone. Perhaps you don't want to. Personal information is exempt. Any information which is personal, anything to do with living identifiable individuals, whether it's patients, students, employees, it's exempt under Section 40. But remember, Section 40 is not an absolute exemption, because the test is, would disclosure breach one of the data protection principles? Because it's not an absolute exemption, that is why we know under FOI what our MPs have been spending our money on. Early on in 2005, there was a case which required MPs' expenses to be disclosed. Senior officers' salaries are often disclosed. Why? Because disclosure would not breach the data protection principles. It would still be fair to disclose senior individuals' information. So Section 40 is an absolute-ish exemption. Somebody rings up your whistleblowers hotline. They ring Crime Stoppers, Dobbin a dealer, etc. Or you've assured somebody confidentiality, part of a counselling service that you offer in the NHS. Or maybe they've submitted a tender which includes a trade secret. Section 41 would apply. It's an absolute exemption. You don't have to disclose it. Information provided by law, prohibited by law, I should say, any court orders, any rule of law, anything in legislation which says this must be kept secret. Freedom of information cannot be used to force you to disclose that information. It is an absolute exemption. Qualified exemptions. That's where you have to apply the public interest test. Public interest test, qualified exemption. So information intended for future publication. You've got a press release, you've got a document, and you're going to publish it in the future, then you have to consider the public interest. Is the public interest better served by waiting for the document to be published in the future, or should it be published now to contribute to a debate of importance? Perhaps there's been an accident in a public building. Perhaps it's something to do with immigration or crime. Would it contribute to a debate of importance? Otherwise, you can withhold information on the basis that it is going to be published in the future. The same with research data. Universities can take advantage of this, but also anyone really. Section 22A. Anything that would harm national security or defense or international relations is exempt under 24, 26, and 27, but remember, subject to a public interest test. Anything that would harm relationships within the UK, as well as that's between Scottish Executive, Northern Ireland Assembly, Welsh Assembly, etc. Anything that would harm the economy of the UK or any part of it is exempt under Section 29. Investigations and proceedings conducted by public authorities. If as a local authority you have an obligation to conduct trading standards investigations, environmental health, planning enforcement, with a view to deciding if somebody's committed a crime, then Section 30 can be applied. Law enforcement. You don't want to disclose any information that would make it easy for someone to commit a criminal offense or for someone to evade capture. So for example, if somebody made a request, please disclose details of buildings where people work at night and often there are lone workers. Section 31, you would not disclose that information. Please disclose what time Securicorp come around to collect the loot. Section 31 would apply. Universities have claimed this when it comes to disclosing information about tests on animals and facilities used for that purpose. Section 31, law enforcement. Audit functions, anything that would harm the audit functions of your organization. If you were a body that carries out audits on other public sector organizations. So it doesn't apply to your internal audit department. Formulation of government policy, Section 35, can only be applied by a government department. So here, colleagues from the Foreign and Commonwealth Office, anything that, if disclosed, would affect the formulation or development of government policy. Section 36, where disclosure would inhibit free and frank advice, deliberations, or would otherwise prejudice the effective conduct of public affairs. Anything that would harm the smooth running of your organization. So this has been applied to the NHS, where somebody wanted to know the geographical telephone numbers of NHS call centers. Other organizations, local authorities have used it to withhold their internal staff directory or details of the software that they use, worried that they could be exposed to hackers. Anything that would involve this, an effect on the smooth running of your organization, or would inhibit people from giving free and frank advice. Anything to do with correspondence with other members of the royal household or honors or titles. Health and safety, if disclosed, if you felt that the information would have an adverse impact on individuals' health or safety. So safety procedures on a building site, for example, security arrangements. Environmental information is also exempt under Section 39. Does anybody know why? Why is environmental information exempt? EIR, that's right, Anita and Belinda. The environmental information regulations cover the environmental information and access to those. Some personal information is exempt as a qualified exemption. Legal professional privilege, any legal advice that you receive, any information that has been gathered for the purpose of legal proceedings is exempt. And commercial interests, information which, if disclosed, would harm your commercial interests or the commercial interests of any other party. So, for example, a local authority may receive innovative sort of bids for a particular service, and that is commercially sensitive information. You may disclose who won the tender, the price that they submitted, but maybe not the sort of innovation that they have included, because you don't want to affect the competition. Section 43, commercial interests. So qualified exemptions, remember, you have to apply the public interest test. The factors for disclosure, openness, accountability, transparency, etc. Factors against disclosure, the prejudicial effect or harm if you disclose the information. So two types of exemptions, absolute and qualified. Before you decide to claim the exemptions, obviously take advice from your Data Freedom of Information officer, from your legal department, and remember, the refusal notice has got to be very detailed, explaining all the factors that you have considered in deciding whether the exemption applies, and also where the public interest lies if it's a qualified exemption. Okay, that brings me to the end of me speaking part. This is your opportunity. Any questions before we go on to do the test? Feel free to type your question into the chat function. Remember, there is a test at the end. Questions, queries, concerns about anything that we have discussed thus far? Before we do the test, let me tell you about what else we do. Have a look at our website, actnow.org.uk. Lots of other articles and resources. We have a blog as well, and you can read more about freedom of information. Also, the subject of the moment, the GDPR, General Data Protection Regulation. We have lots of articles, resources, webinars, as well as other courses on this subject. We're running the GDPR Practitioner Certificate, which is our flagship course at the moment, 4-day course followed by an online assessment and a project that leads to a certificate. The syllabus has been endorsed by the Centre for Information Rights, which is based at the University of Winchester. We also do lots of in-house training as well. Indeed, that's about 80% of our work. We can come into your organization and deliver courses on any aspect of information governance. So have a look at the website for more details about that. Okay, if there are no more questions, then let us do the test.